Yay! People can hear me. Brilliant. My voice is a little crackly today, so I've got a bit of a cold. I do apologise for that in advance, but as long as you can all hear me, fantastic. As is always, this is being recorded. There will be a copy of the recording made available afterwards. You'll get emailed a link, and it's on our YouTube channel as well as on our website. It will be about half an hour of me and Neil talking, who I'll introduce in a moment. And there's an opportunity then for you to ask us some questions, if you have any questions at all. So without further ado, let's kick off. So most of you know, my name is Kelly Peters. I'm a co-founder of Data Basics. And this is the third in the series that we've done of the Eleanor Roosevelt Learning from Data Breaches. And I'm really happy to introduce Neil Partridge, who is our Director of Business Development. Neil, would you like to say a little bit about yourself?
Oh, thanks very much, Kelly. Yes, good morning, or actually good afternoon, just about to everybody. Thanks for the introduction, Kelly. Yes, indeed. So I joined the team. Some of you know me already, but I joined the team unofficially about nearly 2 years ago,
Yeah.
and more officially in March 2020. We all know what that means. So I've been working with the team for some time now, but prior to that, I've been working with my other organisation, PDA Legal. We've been working with Data Basics for about 3 years prior to that, so it's a long relationship. Just very briefly, when people ask me what do I do for a living, actually I say I look for holes. And if you're a client, I'll try and avoid you from falling into them. So I'm by profession really a project manager, consultant, but my speciality areas have traditionally been in the legal sector and, believe it or not, marketing. But of course, both of those dovetail really heavily into data protection. So in a nutshell, I'm here hopefully to add a little bit of context, I think we say, Kelly, into today's session with some real life examples from the legal and other sectors as well.
Brilliant. Thanks very much, Neil. So what we're going to focus on today is two main stories. So we're going to talk about the UK charity Mermaids that was fined £25,000 earlier this year, and then I'm going to talk about a German company in the Lower Saxony area that was fined €65,000 for a breach. And then I'm going to very briefly touch on the crazy fine that is potentially going to be issued to Amazon from Luxembourg, which is an eye-watering £750 million. I'm only going to touch on it because not a lot of detail has been shared as yet. So two meaty breaches to talk about with lessons that we're going to learn, and then I will talk about very briefly Amazon and then how we can help you. So without further ado, let's talk about Mermaids. So Mermaids is a parent support group for children who are transgender or non-gender conforming. So already you're aware that this is an organisation that is handling very sensitive information about a very vulnerable group of individuals. So the charity was registered with the Charity Commission back in 1999, and they were incorporated in 2015. So on the 14th of January 2019, a service user, so it was a parent of the charity, contacted the chief executive of Mermaids and said that they had been approached by a journalist at the Sunday Times who made her aware that her data and the data of her child was viewable on Google, which in itself is incredibly alarming. When you just think about, can you just imagine getting a phone call being told that your child's details is available? Bear in mind that this is a transgender, non-gender conforming charity. My heart would have been palpitating for sure with this. And what they said, that the information that was viewable was emails, confidential emails between the CEO and trustees. It was information about the child's current name as well as their dead name, so what they were previously known as and what was on their birth certificate, their date of birth, the mother's maiden name, the mother's married name, her employer's address, her mobile telephone number, and details of her child's mental physical health. So of information about mermaids that have been already released into the public domain. Now you can see that this was June 2019 that this is what happened, and it took until July 2021 for the Information Commissioner to actually issue a fine. So before I go into any of the real details of this, the first thing I really want to say to anybody is that, as you know, if you're ever issued a financial penalty from the Information Commissioner, it is not as soon as the breach happens. There is an investigation period. There is a period of the Information Commissioner talking to the organisation that's been affected by the breach before any decision of enforcement is actually made. So anyone that believes they're going to be immediately financially impacted by a fine, for example, I just like to stop that right now, because that is not the case at all. But let's actually dig into what was this brief. And I don't know if any of you would have seen this if you read the article in the Sunday Times. It was then followed up in an article on the Guardian and stuff. But essentially, what the breach was that on the 15th of August 2016, bear in mind that the organisation became incorporated in 2015, so it was just a year after. The chief executive was the only employee of the company, and they had 12 trustees. The Mermaid CEO set up an email group as a way of being able to share communications between each other. Now, this was a generic email address called generalinfo@group.io. And between the 15th of August and the 21st of July 2017, that's a 2-year period, this group remained active, after which it became dormant. So I'm already thinking, hold up, 2019 was when someone found out that their data had been leaked. Interestingly, the default setting for this group was groups listed in the directory, publicly viewable messages. So this was the default position that the chief executive chose for this general group. And what the ICO said was actually, in her enforcement notice, was that you failed to properly protect the data and put in appropriate security and technical measures of that particular email group, which then exposed these individuals. Now, there were 780 documents that were available in that 2-year period that were searchable because they were in the group listed in the directory. They were then able to be indexed by Google and then searchable across the entire internet. Now, when the mum phoned up the chief executive, the really positive thing I want to say here is that chief executive immediately recognised that there was a significant issue here and contacted the Information Commissioner. So anyone that has dealt with a breach knows that you need to do that. You've got a 72-hour window when you become aware that there has been a breach, where you have to assess the severity of the breach, how many people have been affected, what is the complexity of the issue, what is the financial, emotional distress that could be impacted on the individuals who've been affected. So clearly, the CEO was aware that this is quite a significant breach. Apologies for coughing. So on the 15th of August, so she notified the Information Commissioner on the 14th of June. On the 17th of June, no more than 3 days later, the CEO contacted the Commissioner with remedial actions that had been taken. Now, these remedial actions included their solicitors contacting Google and saying, please, can you stop indexing this information? They also sent an email to another group called archive.li with the same instructions to say, very sensitive information has been disclosed. It is now cached. Can you please delete it? And then about a month later, the chief executive was then put on to a data protection training course. So what we have here is, it's a very vulnerable group of individuals. a very sensitive amount of information. You might not think that 780 documents is not a lot of information, but when we are assessing a breach, what we are looking at is the impact on the rights and freedoms of those individuals. Now, clearly, the rights and freedoms of those children had been massively affected that could cause them to feel discrimination, and possibly fear, which is what we believe is what's really kind of triggered the Information Commissioners really investigating this into some detail. So, what are the lessons that we can learn from this? What looks like a very simple error that has caused quite a significant impact. So, for me, one of the first lessons that you should learn is, if you know you've had a breach and you know your data is now out there in the public domain, how do we go about recovering that? Because it's not straightforward. You think about Google and you think about the data being available on Google. That's quite a massive exercise in itself. So I think when you're assessing the breach, you need to assess where it has infiltrated. So how big of a breach are we talking about? And how can you recover that? So simple recovery can be, if you sent an email to the wrong person, you'd contact that person and ask them to delete it. That's quite simple. Recovering from a breach could also be about restoring data. But in this instance, it's really about making sure that that sensitive information that is out there in that public domain has been clawed back and is no longer available in those cached stores. So they had solicitors draft up appropriate letters to be able to instruct Google to do this. Both Google and Archive LI did listen and did actually remove the cached document. So lesson one is, we need to be able to recover the data. So we need to know what's been affected to be able to recover that. So a question for you, and it'll be a question that Neil can also contribute to, is if you were to be in a similar situation like this and you were aware that your data or data of your staff or that your customers or the people that you serve had been inadvertently made available on the internet, what would your approach be to recovering that breached data? I'd be really interested in this. So if you're happy to type anything in the chat box, and then whilst you're typing, I'm going to ask Neil, what's your views on this?
Kelly, I think you've presented it very factually, very sympathetically, but actually the whole story is one step away from tragedy. It could very seriously affect people. So this is quite a 750 odd documents is actually a huge impact. I think it exposes a few things that perhaps organisations should consider. I would start by saying it's a people problem, straight off. Lack of control at the top. You often find, I'm a trustee and I'm a director in a couple of charities. Budgets are often very, very tight. Now, quite often charitable organisations are run where trustees have extensive experience in some areas, but quite often data protection isn't one of them. I would suggest that getting advice think about control points. Getting advice up front is a very good idea. The other thing I'd suggest is this is where a data protection impact assessment, a DPIA, and in fact you use certain terminologies already from that, Article 25 and Article 35 of the GDPR. Anybody can access those. And actually, Article 35, here we go, paragraph 6, I think, has 4 points that says what a DPIA must include. It's paragraph 6 or 7. But had a DPIA, data protection impact assessment, been conducted, which assesses the risk to the rights and freedoms, but also in a way helps you to develop a project plan. And I would suggest that a DPIA might also include what would we do if this went wrong. So how then it informs your decision making about how you deal with it. I would suggest another part of that, Kelly, would be mapping your personal data. And you've alluded to that already. It may only be 750 documents initially. Of course, once it gets distributed across the internet, it's fragmented in the billions, millions. But a data map, which should fall out of a DPIA anyway, but a data map would say, this is where we've got it, this is what it's affected. Now, that enables you to, in answer to your question directly, what would your approach to recovering breach data be?
Mhm.
First thing I would do right after I've looked at my data protection impact assessment and my recovery plan, and possibly a business continuity plan, especially if I was a law firm, for instance, or another regulated organisation or a healthcare organisation, I would be saying, okay, get my data map out. What's affected? Where do I need to look? Where do I need to go to get the controls sorted?
Mhm.
Well, I think there's a couple of key points. If you put those in place at the start, you're in a very good place later on. I think the other aspect, before I go on too far with that, because you point yourself, would be another top tip. How would I approach it? I'd approach it from the front and say, make sure the person who's looking after data protection and their deputy, if they've got so many, are trained on spotting them, are trained on dealing with them. And it's about staff training. Certainly in the legal industry, subject access request spotting is a different matter, and that's a different
Mm.
webinar. But reporting and spotting breaches, that's something the legal sector is generally very good at when they recognise it. Confidentiality is at the fore of what they do. They've been thinking about it for decades. But I think it's about informing staff and making sure the people at the top of the chain for data protection know what they are doing. And again, that comes from the data protection impact assessments, the data maps, and understanding what needs to be done.
Excellent. Does anyone have any comments on that? Would any of you involve your legal team? Would any of you be contacting your insurers to see what advice that they might give you in terms of managing such a breach? Would any of you be wanting to bring in a technical specialist to help you analyze the systems to see just how big of an issue this is? I can see someone typing, so I'll give it a moment before I flick on to my next slide. um, Thank you. There is a comment to definitely contact the insurer because they can act as a hub of expertise. So do consider speaking to your insurer. So what is the other lesson that I think you can learn from here? So the ICO was very clear in their enforcement notice. If you want to read it, it's on the ICO website. They said that there was actually alternative settings that the chief executive could have chosen for that group, which would have prevented any of this incident from happening. So this was a totally preventable breach. And what the commissioner stated in the notice was that the service could have chosen something like groups not listed in the directory, publicly viewable messages, or groups listed in directory private messages. So by choosing those particular settings alone, it would have prevented this breach from happening. So the lesson is, and what the commissioner then said was that she could find no evidence of the rationale that the chief executive took. Now, admittedly, this is one person in a very tiny charity at this moment in time, that technology may not have been her area of expertise, but it was still why did you choose this particular group? Why did you choose this particular setting? Um, and did you understand that this setting you chose by default would have published all of these? So where was the evidence? And if we can remember that in the regulation, accountability underpins the core principles of the regulation. And what it's trying to say is we want documented decision making available to us, so we understand what was your thinking about that. So um, for those of you that have joined us today, what is your approach to documenting decisions when processing data? When you adopt a new system or you take on a new download a new app, for example, is there do staff know, or do you know what a process that you would follow to say, this is why I chose this system, this is how I'm going to use it, and these are the security settings that we're going to choose? Any comments? I can see someone typing. So, Neil, is there anything whilst we're waiting for this response? Is there anything that you would briefly add here?
I think I would. I think there's an element there of, and again, I can draw some, if you like, some analogies from the legal sector, for instance, where things have been very well documented for a long time. insurers and law firms are speaking all the time, and there's some very good insight to come from those. One of the things we are seeing is obviously things like remote working isn't necessarily promoting the best in data security at the moment, but we're all having to deal with it. So it's things like when you talk about devices and how to make those devices work, is yes, do you know what devices your team are using? What is on their asset register? What controls do they have? Are the devices patched? So I can see the questions coming, so I'll be silent for a moment. But I think it's about understanding what you have and how you use it, and very importantly, documenting that.
Yeah, absolutely. And I think that um, even as a small organization, it might just be that you've got a note in an email, in your email system, or you've got something in a folder that talks about data protection that says this was your decision, why you chose this system at that. So I think for me, the important thing is that if you're going to use something that's definitely, if it's going to be internet based, which a lot of what we're doing in today's day and age, and the pandemic has really pushed us towards, is we need to absolutely consider the security aspects of that, and what are the implications if we get that wrong. And as you can see, some of the comments are, it's definitely vital to have accountability documented. Um, Now, I appreciate this might not be on everyone's forefront, but if the people on this webinar or the people listening afterwards are responsible for data protection, these are some of the questions that you will get asked if you ever get investigated by the Information Commissioner. So, it's what lessons can we learn from other people's mistakes that we can implement. And the other lesson, which kind of comes on to your point, Neil, which is that people are something that are vital to the security of our business. And as I mentioned earlier, that this chief executive was actually done a half-day training course after the breach had been notified to the commissioner and was being investigated. But one of the questions that you'll always get asked if you've ever had to report a breach to the Information Commissioner, one of the questions that she will ask you was, when was the last time your staff was trained on data protection? And in this case, the ICO said that all Mermaid staff and volunteers had received mandatory training back in 2018, which is updated annually. So you think, oh, that's really great. They're having regular training. The feedback was that if this was the case, how was it not aware? How was no one aware that this information was out there in the public domain? And it's really interesting because I was having a conversation only this week about this very matter, is that you can have a policy, very much like you can have the best technology, but if your staff don't know that policy exists and they've done the training and it's tick, how do you make it more practical? How do you get them to, as staff, to take a little bit more ownership of, oh, that looks a little bit odd. I think that might be wrong. I need to tell somebody about that. So it's not enough just to have a policy in place and to offer training. It's about really raising that awareness within the staff so they can question things and say, that doesn't make sense to me. So the ICO's commentary was, you may be doing these annual training, but it's clearly not sufficient because none of your staff was able to identify the fact that this was an actual problem. So I think we all need to take a moment and think about the training that we've all received, or that we may even deliver, and say, okay, will staff understand what I'm trying to convey here? Did they understand the complexities of the regulation in a simple way and how it applies to our business? Neil?
Oh, I'm just wondering how long we've got on this. We've got a couple of minutes.
Not a lot.
Can I? I think there's a few observations, but maybe a couple of questions I'd like to try and project at this point. I think first of all, we're all challenged by the fact that what we do at home on computers quite often is different to what we do for work on computers.
Mm-hmm.
But because we're used to doing it one way at home, and there's no real consequences, or is there, by doing it at home? And I'm talking about like watching television through the internet or playing a game on your iPad, or your children doing the homework on the internet. But essentially, it's the same conduit. Again, drawing an analogy from a law firm, I visit two types of law firms. on a regular basis, and every year I must talk to 200 or 300 firms. But this applies to everybody. They fall into two schools. There's the ones who say, yes, we've done the mandatory training, which is code for, we've parked all our staff in front of a half hour, boring as anything. This is data subject access request, this is a data breach training, and they've not properly evaluated it. And then they wonder why there's a problem later on. Of course, the ICO is a bit smarter than that, will work that out. The other school of firms, the ones that tend to do very well with this, are the ones that actually evaluate the value of the training. So I'm wondering if there's a couple of things there, and I encourage organizations to do this, large and small, whether they're law firms or not, is do your training, but I would say do a bit of prompting or training at least every month. Don't leave it to an annual thing. And a prompt can be something as simple as an email from somebody senior. The other thing I'd say is when you do your training, based on your data protection policy, and get each member of staff once a year to sign the data protection policy to say, I have read and understood it, and pop it into their file. It doesn't protect you, but it gives you a layer of armor to show you've tried to do something. But I would also, as well as all of the newer things that's coming out, and again, this is from the legal sector where there is actually an increased, the SRA, which is the law sector regulator for most firms, is saying we want enhanced evidence now of competence. Now that is about legal competence, but it's also about the safeguards that support the legal competence. So how are you but everybody can do this, as an organization, maybe consider doing skills audit. What do your people really know and understand? Consider the key things you absolutely must comply with. And in this modern world, there is no organization, even if you're laying bricks or moving things around a supermarket, it doesn't matter. Data is part of your world. So understand that that's a key factor maybe, and say, okay, let's do a skills audit. What do people really understand? Have we evaluated it? Because when the ICO comes knocking one day, and maybe insurers are going to ask these questions, and they are asking of law firms, I know, you'd be able to say, this is how we're doing it, this is how we're monitoring it. And what actually comes along with that, and I'm going to pause for a second, what comes along with that as well is you start to change the culture of your business. And a lot of firms, a lot of organizations struggle with this because the people, I'm using the phrase at the top, people in certain situations have said, we've got away with it for so long, do we really need to do this? When you start to introduce conversation, you start to evaluate, you get feedback, and you change the culture. And that's one way to actually do it very positively.
Cool. And does anyone have any comments on that? Would you be confident that your staff would be able to identify a breach and let you know? I appreciate you might not be comfortable sharing it here on the webinar, but do you have any comments about the training and how you could link up training with policies? Okay, I'm mindful of time, so I'm going to kick off to our next one. Our next breach, and the company wasn't known, they wasn't named it in Germany, but in Lower Saxony, a company was fined 65,000 euros for operating a website with outdated software. Now, the reason I brought this is because in the UK, we've had a very limited number of fines. But I actually find, because GDPR is obviously a European legislation, there are things that we can learn from other countries and other countries' interpretation of the regulation and why they're fining companies. So the reason I thought this was really interesting was the fact that this company was using a software solution that was out of date and had been out of date for a significant period of time. And what the Data Protection Authority in Germany stated was that, you didn't just have inappropriate software on your website. Actually, you exposed people's passwords in a very easy, viewable format. So rather than it being hashed in such a way that it cannot be viewable, or they were not very pleased, I think is the best way to phrase that. So what the Data Protection Authority said was, when they got this notification that there'd been a breach, the company notified the German authority, very much like Mermaids notified the ICO. So well done to both of those companies for recognizing their responsibilities. what the commissioner decided that they were going to do was they're going to investigate this, because they found that it was a little bit odd that this breach of passwords was even viable with the current state of technology out there. So what they did as part of their investigation was that they looked at the web shops application, and they actually found that it was a version that was available in 2014. What's to add to this company's woes was that the developer of the platform that the company was using made them aware that there were significant vulnerabilities in the software, and it was their responsibility to update it so that they could patch the problem and reduce the risk of a SQL injection from third-party external sources. What they also found is actually the technical approach that they had taken to protect passwords was actually woefully inadequate. So they were quite stinging in their comment about this. So it the commonalities between both of these is that there were technical issues that were easily both breaches were easily preventable had both organizations taken a bit more consideration about protecting the data appropriately. So it should be really no surprise that the lessons I really want to learn here, there are two over 3 slides. So this is really about patch management. Now, the reason I've got a whole lot of information on here is because if I can take you back to Carphone Warehouse, which was 2019, they got reprimanded by the Information Commissioner because their point of sale software hadn't been updated. So this is a very common error that happens across organizations, in that simply software systems have not been updated, whether it be websites, devices, or hardware. So any kind of system you're using, whether it be Windows, it would be a Mac, it be any kind of third-party software vendor, they will notify you of vulnerabilities that they have identified in their software, and they would advise you when the patch is going to come out, and then they will actually ask you to apply that patch. And an interesting statistic here was that 57% of cyber attack victims stated that applying a patch would have prevented the attack, which should be of no surprise. But more shockingly, 34% of those actually knew the vulnerability. So the lesson I would want all of you here to be thinking about is, do you know the state of your software hardware across your organization? Now, I don't know the different sizes of organizations that are here, but do you have a list of assets, both software and hardware? And do you know the version that they're on? Do you know when was they last updated? Now, you might not know, but your IT people may do. And how often do they get updated about bugs? And how do they prioritize which systems get updated first? So if you have mission critical systems, that absolutely, if there's something that makes you vulnerable, the patch gets applied almost immediately, versus something that's a little less risky. So do you know your vulnerabilities in your organization? How do you go about plugging those vulnerabilities? And again, coming back to the accountability element of the regulation, it's your responsibility to make sure you plug those holes. Because if you don't, this can be that you could be in the same situation as the Lower Saxony company. So we don't have much time, so I'm going to ask Neil to have a brief, succinct kind of, what would your approach be to rolling out software updates, Neil?
Thank you very much, Kelly. I think, again, it's a human problem. This is not a computer problem. So if I summarise where we are with this, I think the answer is to recognise, first of all, that the software provider, we could be talking about websites, or if you're a law firm, a case management system, if you're a sales organisation, a customer relationship software program, they're being updated all the time. And like anything else, just because it's done once doesn't mean it's going to be okay forever. Cookies is another discussion, but quite often software is updated, and cookies which you've told your developer not to use, find their way back on. So I would consider, first of all, setting yourselves up and recognizing that not the providers, but you as the organization instructing the provider, you are the ones responsible. You can have a go at the provider, but it's not their problem. It's actually your challenge. So I would say to firms, all organisations, it is well worth doing an annual review and documenting the annual review. Where are we with the software? Look at your plan, and it could be your website, it could be case management software, it could be customer management software or patient management software, credit control, doesn't matter. Is it mission critical? What's involved? Have we talked to our provider? Have we documented that we're happy it's still there? Are there any patches? Do we know or don't we know? No, go and ask an expert. Now, what actually falls out of that is, from there you can identify what we need to do and when we need to do it. Take it a stage further, what I've seen law firms do very successfully is use that compliance review, that risk review, to actually save money. Now, that sounds bonkers, I know. But what they do is they actually look at this and say, right, we've got a budget of X to spend on our hardware and software. Sometimes you need new hardware to run new software. But we've looked at that, we know where our risks are, and this is a running order of a prioritization that we want to update or apply patches, or this is the resource we need to do to manage the patches. And the interesting thing there, Kelly, is I know of 3 firms recently that have done that and actually saved money by economizing on what they did. So I think if you're looking for a way in sometimes to influence the culture and the purchasing culture in the organization, to say, yes, this is one of those awful compliance things, but it's a very much something we need to do. But say to the person who also controls the purse strings, this might actually save us money. So my little top tip there is this actually has financial benefit, or it could do in some cases. But I'd say monitor what you do, realize it's a human issue, realize software is often updated without you knowing, or patches come out without you knowing. Talk to the experts. The way to do that is to take ownership and do a documented, at least annual review of where you are in your landscape and the key factors affecting what you need to achieve.
Yeah, and certainly one of the questions I always ask when I audit companies is, can you provide me with a list of all of the systems that you have and how up to date they are? Do you have any unsupported software systems on your network? Mostly they turn around to me and say no, but I have had the odd one or two where they're like, well, yes. And I'm like, well, how are you managing that risk? Because it is a risk. It is a vulnerability on your network that you need to manage.
The other one, you're quite right, Kelly, but even those who say, yes, we know that, I talk to them, law firms have got to have this, but I talk to them all the time. Anybody with cyber essentials has got to have this. But then I ask, well, is anybody, even one of the directors, using their own devices for remote working? Yes. Have you logged that? No. So you've got to take into account anything that can interact with your system, and is that up to date, and has that been documented?
Which leads me beautifully into the second lesson, which is about having that software, hardware inventory. So as part of data protection, you have to, it's recommended that you have a register of process and activity. So this is different. This is actually you having a list of the different hardware, software that you have that is connected to your infrastructure, and it should be comprehensive. And like Neil said, if you've got members of staff using their own devices to connect to your network, do you know what they are? How do you manage that access? Do you limit what they're able to see? In the incidence of this Lower Saxony, it would have been really useful for them to know the different systems they had in use and the different versions of software and just how out of date that was. But for me, if you have this kind of inventory and it's regularly maintained and you can do an annual check, it gives you a much better picture of where your vulnerabilities are, and it allows you to understand also what computers and what software systems are about to come out of their supported life cycle. So Microsoft will tell you this software is no longer going to be supported. What's your exit from that? What's your costing to be able to move to the next solution going to be? And like Neil said, could it be a cost saving? And most importantly, really assign the kind of what are mission critical. So know what systems you need to patch, but really know what your critical systems are and what how vulnerable they are and what priorities you're going to put to make sure that they become the first come first serve kind of. If there's a patch, this one has to get done first. So do have a software hardware inventory. If you're a very small company, this should be relatively easy to do. It doesn't need to be overly complex. If you're a large organization, it's just about maintaining that list. But that kind of comes on from what Neil was just saying. So before I talk about Amazon, which is going to be very brief, does anyone have anything they want to add to the lessons I've just talked about in terms of patch management or hardware, software inventory? Is this something that you would think could be beneficial in your organizations, or do you already have that in place? Cool. I'll wait a moment. I can see I've got some typing going on. I'll come back to the comment. So if you're typing, I will come back to it. So I think a lot of what I've covered here, some of this is going to be for small organizations. It might seem a little bit overwhelming. It might be, well, do I really need that? I think it all comes back to the core principle of the security principle is that you need to put in place reasonable and appropriate technical and operational measures that are proportionate to what you're processing. So for me, if you are even if you're just a one-man band, you need to know what security you need to put in place to protect the data that you are responsible for, but it has to be proportionate to your business, and it has to be appropriate for the type of data that you're processing. um then now, I'm sure more will come of this Amazon story, but it was such a phenomenal amount of money. I just wanted to touch on it. But the reason I wanted to touch on this is because it's something that we're seeing a lot more of, is that this came from a complaint from a civil liberties group that represented 10,000 customers, where they were claiming that Amazon's advertising system wasn't based on free consent at all. And we're starting to see a lot of customers being approached by individuals who are saying, I feel that you are misusing my information, and they are putting individual complaints in to customers. So it's not just complaining to the information commissioner, it's also them taking individual complaints. Now, this is obviously a massive complaint, and it'd be really interesting to see. But I just wanted to make it aware that um, we're starting to see a lot more individuals are understanding the power that they can start asking of companies about how their data is being processed, why it's being processed, and if they feel that it's being misused or inappropriately processed, they have the right to take the decision to seek compensation, which at the moment is about up to £3,000. So we've got about 2 minutes for questions. Does anyone have any questions from today's session? Probably stunned you all into silence on a Friday afternoon. So what I'm going to do is, I can see someone's typing. I'm just going to talk you through some of the things that we can quickly offer, and then I'll come back if there are any questions. So, as you know, for anyone that's come to our webinars in before, you are entitled to a free half-an-hour call with me. You simply can use the Calendarly invitation. You'll get this on the slides after the event. We also have our catalogue, which is also downloadable in the chat. So please download it. It has a list of all of our products and services, including our full range of data protection training courses that we have available. We also offer a best practice group, which, as you can see, is a confidential group. It's structured discussions that is chaired by Neil and Regina. It happens once every 6 months. It's no cost. It's a fabulous way of being able to share any data protection concerns. If you're interested, please email the info at box. Also, you can connect with us on all of our social media channels. You can sign up to our newsletter, and you'll get notified of future webinars. Our next webinar next month is going to be about the proposed changes that the UK government want to make to data protection. So it might be something that you want to come along to. And thank you for the comments I can see in the chat box. So if there are no other questions, as is always, I really appreciate the fact that you've given us your time today. Thank you very much for that. Thank you, Neil, for joining me.
It's been a pleasure.
I hope you all have a